Good morning, everyone, and welcome to the New Possibilities Hour, part of the Will Work for Food project founded by Natalie Armstrong-Motin. Every Thursday, Jean Lawler and I are delighted to host another cutting-edge webinar for mediators, arbitrators, lawyers, and everyone who negotiates. As you know, there's no charge for these great webinars. Rather, we invite you to contribute to a food bank if you like what you see. And so far, our audiences have been so generous. One of my favorite parts of the webinar each week is when we announce the running total of just how much people have contributed in honor of our great speakers. Jean Lawler, would you please do the honors?
With pleasure, Jeff. Thank you. Hello, everyone, and good morning, good afternoon, good evening, wherever the time finds you in the world. We have been told so far of donations to various food banks around the globe, 600,000, 6,606, then a comma, $632.57. So that's well over 6 million meals that have been served thanks to the generosity of this group. You know, 650 is in my headlights. So looking forward to how fast we get to that, and for your generosity. Thanks so much for being here.
Thank you so much, Jean. And now for today's program with Jaime Bustamante, Produce Resolution, Insights from the Fruit and Vegetable Dispute Resolution Corporation, an ADR tool for the produce industry. We're going to learn about the dispute resolution model, which is designed to reduce risk and facilitate trade between members of the Fruit and Vegetable Dispute Resolution Corporation, DRC, a nonprofit membership-based organization serving the produce trade. DRC provides harmonized standards, procedures, and services to its members to help them avoid commercial disputes. When differences of opinion occur, they provide consultation, mediation, and arbitration services to resolve the issue in a timely and cost-effective manner, and literally keep food on our tables. Jaime Bustamante, our presenter today, grew up in the agricultural community of Hermosillo, Sonora, Mexico. After completing his bachelor's degree in foreign trade at the University of Valle de Mexico in Mexico City, Jaime started working with DRC in 2002 and is currently the Director of Trading Assistance. He joined DRC as a trading assistance specialist in the DRC Mexico office and played an integral role in getting the DRC Mexico office up and running. In 2005, DRC consolidated its offices, and Jaime moved to Ottawa, Ontario, Canada, to join the DRC in its Ottawa offices. In his current position as Director of Trading Assistance, Jaime oversees all trading assistance services, including helping members identify potential customers, private and confidential consultations, the informal mediation process, the arbitration process, and education and training for members. He is also involved in different DRC projects. He has assisted DRC members resolve thousands of produce and transportation disputes in his role with the DRC Trading Assistance Team. Jaime Bustamante, please tell us a few words about the food bank to which you would like people to contribute if they are able, and then on with the presentation. The floor is yours.
Thank you, Jeff, and thank you the whole team of Will Work for Food initiative. The Ottawa Food Bank has been operating for close to 40 years in the Ottawa region, serving hundreds of thousands meals for that period of time. And as we probably all know, food banks have been struggling after the pandemic to get caught with inventory and donations to be able to support the communities. And the Ottawa Food Bank has had these issues maintaining their services. And so I feel this is a good opportunity for them, hopefully, to get some funds so that they can become what they were prior to the pandemic in terms of inventory and being able to help the community in Ottawa. Yep. And well, when it comes to what the DRC and what we do, I think you had a good explanation there in your introduction. And just to understand a little bit better where the DRC comes from, the DRC was created back when NAFTA was created between Mexico, United States, and Canada to help the private industry or food industry resolve disputes without the need of the governments intervening. And they used two models, or the DRC combined two models to be created, which was the Perishable Agricultural Commodities Act in the United States, which provided licensing services for the food industry, plus mediation and arbitration services, and the Canadian Food Inspection Agency licensing and arbitration regulations, which also provided for Canadians the same services. So NAFTA gets created and they say, well, we need something to help not just each country, but something international, all three countries. And after several meetings between industry, governments from the three countries, the DRC was created in 1999. And since then, our services have expanded to also cover companies in the produce industry outside of North America, so that they can join and enjoy the services and take advantage of the services that the DRC offers to the produce industry, which is a very complex industry to understand how it works when you're not familiar with it, because one of the most interesting things that someone that gets involved in a dispute between companies doesn't see, it's a contract. Contracts in the industry of the produce industry, fresh fruit and vegetable industry, rarely are written. Everything is through phone calls, exchange of emails, or what it used to be faxes. Now is text messages, or contracts get created just on a day-to-day basis without the need of actually written contracts. And that creates an issue when you don't have a platform or a background that tells companies what they need to do, how they need to operate, what are the rights and responsibilities in a contractual relationship, which DRC rules and regulations provide by default to all the buyers and sellers of produce, including transportation companies in the produce industry. And so the DRC has been able to promote their services in the industry to become a leading arbitration organization in this industry, which there's only a similar mechanism in the US run by the government, by the US Department of Agriculture, but anywhere else in the world, there's nothing similar to us. An organism that not just provides a platform for dispute resolution, but also provides rules and regulations that members have to follow in order to avoid disputes and being able to establish strict rights and responsibilities, or understand the rights and responsibilities in a produce transaction. Jeff, is this going to be more of a questions and answer, or I can just continue talking about it?
Please just continue. Tell us about the kinds of disputes that you all typically handle, which ones get arbitrated, which ones get mediated, and the kinds of things that are most important to your members in getting disputes resolved.
Sure. So one of the funny things, normally when I give my presentations, I start by saying, we're here to resolve food fights, which sounds normally funny, and it's a good way to start with any kind of presentation. But beyond that, so what we try to do with buyers and sellers in the produce industry, whether they're members of ours or not, is help them understand all possible problems that they can find in a transaction and guide them on how to avoid them by providing webinars, seminars, making them understand our rules, how they work. And if they get into any trouble, then that's when our mediation and arbitration services enter to play. So for example, one of the most common disputes that we find in our industry is when we're talking about product, and think about Canada to begin with. Canada obviously is not a big growing country for fresh fruit and vegetables. their season for growing fresh fruit and vegetables is very short. So a lot of the produce is imported either from the US, from Canada, South America, Europe, Africa, Asia, and produce is having its perishable nature. Once it's caught, once it's harvested, that product starts to die. And obviously you have to take into consideration the transit time that it would take from the farm to normally the final seller to the final consumer, which would be a retailer, right? And also that product passes through several hands prior to getting to the retail store. It could be a distributor, it could be a wholesaler. And so normally is shipped from origin in terms of quality doesn't necessarily arrive to the final destination in the same quality and condition, because the product matures, evolves, some defects or condition defects start appearing on the fruit or the vegetable. So the disagreements normally occur when, as a buyer, we receive that fruit, or a buyer receives that fruit or vegetable, and it finds that it has 8% decay on the total load. So that means that obviously 8% of that load no longer has commercial value. How am I going to make money with product that I thought it was going to be 100%, and I was expecting to make a profit out of the sales of this product? So most of the disputes occur because either the product that was shipped does not arrive meeting certain specs or standards. In our industry are known as good arrival guidelines or good delivery guidelines. These guidelines establish the total percentage of defects that a product can have at shipping point or at destination. So, and how we can corroborate whether a product can meet or fail those specs or those good delivery guidelines is by getting government inspections, quality and condition government inspections, whether in the US or Canada. And anywhere else in the world, governments don't provide a similar service, but there are private inspection surveys, companies that provide these kinds of reports. Based on those reports that normally report the number of percentage of average of defects, we can determine how much of that product has problems, and if those problems are within the tolerances that are given for the transit time that occurs from shipping point to the final destination, or if they surpass them. And if they surpass them, that means that the buyer has a right to claim damages on the product. Whereas if the product meets those tolerance of defects established by good arrival, good delivery, or whatever specs the parties established, then the buyer is still obligated to pay the full invoice price to the shipper or the seller. So normally you see product arriving with some decay, with some discoloration, with some bruises, and that when the parties fail to come to an agreement on what would be a fair price for that product, that's when we intervene with our tools, the DRC tools offer through our trading standards and good arrival guidelines and other policies to help them establish what would be a fair market value for product at that point. So that's one of the main disputes that we helped resolve. The other ones also have to do with transportation. Transportation is a key important factor in the moving of through countries of fresh produce, because the cold chain is very important. Compatibility of the products is very important, and not just in terms of ethylene producers or other qualities of the product, but also temperature-wise. Products need, depending on the product, there's a different temperatures that are required for the transit of those commodities. And so we try to make sure that the companies, including the transportation companies, know what are those guidelines, what are those restrictions or limitations or different rules that must apply or they should follow in order to avoid a possible dispute that at the end of the day, you want to avoid. The transportation companies don't want to be the ones at fault for creating more deterioration in transit to the commodities. So transportation companies didn't have the opportunity to join the DRC immediately when the DRC was created. We created rules for them in 2006, and we allowed them to start joining since 2006. And now we have a lot of ground transportation companies that are members of the DRC in the United States and Canada. And they're very happy to use us to help them resolve disputes and determining where the liability is, and whether it's a transportation problem, whether it was a shipper problem, or sometimes, which happens, some of the receivers and buyers in the industry do not follow the proper procedure to demonstrate that the product arrived in deteriorated condition, and that prevents them from actually claiming damages properly. We through our process, help them understand where the mistakes are, how to avoid them in the future, how to maintain the business relationship, which is something very important for us. We don't want to disrupt the buying and selling or transportation between companies. We actually want to help them continue doing business by pointing out to them, here's the problem, here's where the issue was. From now on, if you continue doing business and just accept the liability, then you most likely won't incur in this problem again. And if you incur in this problem again, you have now a precedent, something that can help you. Okay, we went through this before. Let's resolve it, because we know where it's going to go if it goes to the dispute resolution process of the DRC. Now, talking about the dispute resolution process of the DRC, companies are obligated to bring their disputes within 9 months from when they became aware the dispute arose. So that's a limitation of claims that we have, because we want to help our members resolve disputes as soon as possible, as fast as possible. And so if someone knows from the beginning that they have 9 months from when, let's say, the invoice was not paid, or when they received the inspection report showing the product failed to meet contract terms and they did not agree on a settlement, that from that day, they have 9 months to file. Now, prior to filing a claim through the DRC, they can actually talk to us and have those private and confidential consultations, so we can advise them on how to negotiate a possible settlement with the companies. The DRC, in the past, we've been operating for over 20 years now, almost 25 years. And at the beginning, there was a lot of consultations, a lot of claims filed, a lot of arbitrations. Right now, in the past 5 years, the number of consultations have increased, private and confidential consultations have increased, and the number of claims have decreased, and the number of arbitrations have decreased, because we believe we've been doing a good job educating the industry with the work that we've been doing since the beginning. So right now we're handling between 80 to 100 claims a year, formal claims presented. And out of those claims, only between 15 and 20 go to arbitration. And so how does that happen? Like I said, the first part is the private confidential consultations. If the dispute doesn't get resolved during that part of the process, then the party has the right to file an informal complaint, which we call a notice of dispute. They file that notice of dispute, and then we confirm receiving that notice of dispute. It provides 7 days to the respondent to provide a reply. From then on, we have a 21-day period for informal mediation, where we study the case, we contact the parties, we provide feedback, an overview of the file, helping them understand where the problem was, who's liable for that, et cetera, et cetera. And then with that, normally we can say that between 75 to 85% of the disputes get resolved during that process. For the produce industry, since we're talking about perishable commodities, that by the time we're in the dispute, that product has been sold or has been destroyed or no longer has commercial value, that's pretty fast. Let's say the informal mediation is not successful. Parties have 12 months from the date their notice of dispute was confirmed to file for arbitration, to file a statement of claim, to initiate the arbitration process. And we have three types of arbitration process. The first two are expedited arbitration process or processes. And for claims, this is another thing in our industry, our claims are normally for a small amount of money. For claims below 15,000 US dollars, the cost for arbitration with us is only $600. They don't spend more money on getting a final arbitration decision and award. And it's an expedited process also because it only takes 60 days to get it resolved, to get a final decision from the arbitrator. So a party submits a statement of claim. The other party has 21 days to submit a statement of defense. From the receipt of the statement of defense, the claimant has the opportunity to provide a reply within 10 days. Then it's 30 days for the arbitrator, after the reply to statement of defense is received, for him to submit his decision. And it's a limited based decision. The arbitrator doesn't have to go deep into explaining the whole details of the case. The arbitrator can make a decision based on limited explanation of on how he arrived to, or she arrived at his final decision and award. For the produce industry, that's still a long time, but is much less or shorter time than going through the courts to try to resolve a $15,000 claim. The other arbitration that is also expedited is for claims between $15,000 and $50,000. Same process, but now we do ask the arbitrator to spend a little bit more time submitting his decision and explaining a little bit better, so that it can be also a more educational piece for our members, for the two parties who are involved in that dispute. Our rules do say that only one arbitrator is required for these procedures. There's no need to have more than one. So that also keeps the cost of the arbitration way below what would be the standard for any other arbitration organization fees, the fees that they will charge. So for claims between $15,000 and $50,000, arbitrators are paid between $1,500 to $3,000. That's what we estimate. Now, an important part before we get to that third type of arbitration is that the DRC becomes not an advisor, but we can help the arbitrators understand how our rules work, how our process works. So we are a tool for the arbitrator to use when he's making his decision. We don't intervene in the decision making of the arbitrator, but if the arbitrator has questions, they can always ask us, and we can always provide advice on what the rules say, not on the merits of the case, but on what the procedure, arbitral proceeding, or what the rules say, but not intervening in his decision making or providing any kind of opinion. So that also helps the arbitrator make an arbitration decision that it goes along with what is required for the industry to understand in terms of what rules apply to the produce industry. The third arbitration part is the formal arbitration, which is for claims over 50,000 US dollars. And for those claims, the difference is that it's not an expedited process. So now you have 30 days to provide a defense to the statement of claim. The arbitrator gets paid his hourly fee on whatever time he spends on arbitrating the file. Also, a hearing is required. So before COVID, making arrangements or scheduling a hearing where both parties needed to be present in front of an arbitrator, added a lot of cost and time to the process. So we were normally spending between 120 to 160 days getting to a final resolution. Still very fast compared to other procedures out there, being a formal process. But now COVID, one of the good things that COVID pandemic brought to us was the virtual hearings. And with virtual hearings, we've been able to reduce the amount of time that that a formal arbitration proceeding lasts, and reduce it to between 90 to 120 days, which again is really fast to any other proceeding out there. We're seeing like most of the disputes that are now going to arbitration are normally over $50,000. Normally the parties are very happy with the results, with how fast it is resolved. Obviously the party that loses is never happy, but they get a fast resolution. And they learn from the experience. And so all in all, our members are very happy with our procedure. Right now, we have over 1,700 companies that are members of the DRC. In Canada, it is mandatory for produce buyers and sellers to be members of the DRC. The Safe Food for Canadian regulations makes it a requirement by law for Canadian companies to be members of the DRC. So any company outside of Canada who wants to sell produce to a company in Canada, if they join the DRC, their transactions will be automatically covered because we will have jurisdiction. And the way we have jurisdiction is very simple, because once you join the DRC, what you're actually doing is signing an arbitration agreement that says that any dispute with any other member of the DRC will be exclusively resolved through our dispute resolution process. So that forces them, any company who is a member, to get access to our dispute resolution process. So that's very important. The other part is like Jeff mentioned at the beginning, we're a non-for-profit organization. We don't charge for our services when it comes to our dispute resolution process, our consultation process, our informal mediation process. How we get funds is through the membership. So companies to have access have to pay a membership to become a member for a year, and every year that membership is renewed. And as long as you renew your membership, all of your transactions with other DRC members will be automatically covered, and we would have jurisdiction to use our mechanism to resolve the dispute. Another important part of the DRC is that when the DRC originally was created, it had a jurisdictional limitation. The DRC could only resolve disputes where the product in the transaction entered into commerce in North America. So the product needed to come in and out of Mexico, United States, and Canada for the DRC to have jurisdiction. That limitation was recently erased from our rules, which means that now the product can be shipped from Argentina to Europe, and those two companies, if they're members of the DRC, we would have jurisdiction to resolve that dispute. That's something that we hope it can give us better expansion or more expansion in the world to become like the world dispute resolution mechanism, and not just a North American dispute resolution mechanism, which is what it was until August of this year. We are actually looking to expand our roster of arbitrators because right now we have a roster of 30 arbitrators, and most of them are from Mexico, United States, and Canada, because we're going through that, expanding our services outside to Europe, South America, and Africa and Asia. So we are in the process of looking for arbitrators outside of North America that would like to be part of our system. We're looking forward to expand that service. Obviously, expand our services would be connected to the number of disputes that we receive from now on. So if the number of claims, because of the number of members increases, obviously the number of disputes may increase, and then we will need to expand our roster. Right now, we believe we have 30 pretty good arbitrators familiar with our industry, and we're very happy with what we're doing for the fresh fruit and vegetable industry, not just in North America, but in other parts of the world at this point.
This is fascinating, Jaime. Can you give us examples of a typical dispute? There are three categories: the under $15,000, and then the mid-range, and then the larger ones that get a more elaborate process. Can you give us an example of the typical dispute in each category?
Sure. Well, normally for a dispute below $15,000, let's say a load of avocados coming from Mexico to Canada, that can, depending on the time of the year, it can be between $28,000 to $47,000. But the product is shipped, it arrives in Canada, it has some issues, it has some problems with quality, and then the receiver decides to pay only $14,000 out of a $30,000 invoice. So because the amount in dispute is less than $15,000, in expedited arbitration under 15 will automatically apply to that dispute. Obviously, that is if it was not resolved during the informal mediation process.
Yeah.
But we're talking for also not full loads of avocados. Sometimes for other products, there's only a few pallets that are shipped, and those can cost $5,000, $6,000, $7,000. So a full invoice is in dispute. Yeah.
So, excuse me, Jimmy. So in that case, the seller would be what, a farmer or grower in
It can be a grower, it can be a distributor, it could be a wholesaler fighting through that chain of the contract chain, or it could be against a retailer. One of the good things the DRC has in Canada is the retailers are members of the DRC. So if someone has an issue with the retailer short paying an invoice or not wanting to pay what was agreed, the DRC can intervene, and they're obligated to pay, because otherwise, if they don't pay that arbitration award that they lose, if the company's in Canada, we take away their membership, and they can no longer operate in the industry, because without the DRC, they can no longer import product from outside of the country or interprovincially. So we do have a very strong hand when it comes to enforcing our arbitration decisions and rules within the industry.
So so it could be between any two people or any two entities at any point in the food chain. It's not necessarily a grower and a supermarket. I mean, those would be the two ends of the food chain.
Correct. Right? Normally, most of the disputes are between the distributor or a shipper. A shipper is someone that is working to sell or market the products of a grower, who sells it to another distributor or a wholesaler, because how the industry works is sometimes these wholesalers have the vendor agreements with the retailers, and they're the ones supplying the retailers with the produce that they need. Retailers do buy directly from growers, and it's an initiative that has been promoted all over the world, for especially in North America, for over the past 10, 20 years. But it's but sometimes it's complicated for retailers to handle the logistics of importing such a variety of commodities that they want to put in their shelves. So it's easier to have a wholesaler or a distributor have an agreement with them, for them to look for that product within the country or outside of the country, or and have it ready for them. So normally the disputes that we handle are between the grower shipper and the distributor and wholesaler. And so they come into agreements that, like I mentioned before, rarely includes a contract. Everything is on the phone, text messages. And for our purposes, the DRC respects whatever contract or specs are created between the parties, but where those elements on that transaction that they were able to establish are silent, our rules and regulations, trading standards, good arrival guidelines, good delivery guidelines, and all the policies that apply by default to the transaction. And that's one way to make sure that everyone gets protected, right? Like I mentioned, our rules and regulations establish the rights and responsibilities each party in a transaction has as a buyer or a seller. So is normally when either the shipper or seller doesn't ship their best product that we have issues, because again, from origin to the destination, the product changes and it's going to arrive with certain problems. Not all the cartons that are bought are going to arrive in sound condition. There's going to be some that are going to be damaged, and then there's making the decision on whether those losses are sufficient to make a claim against the shipper or the grower or the distributor, or simply say no, because we know that with the good product that we receive, we're going to make enough profit to cover those losses. When it becomes a bigger issue is when the transportation company is involved, and then they go through their insurance to try to make the claim to the insurance, and the insurance says no, because then the carrier or the freight contractor becomes responsible to pay the value of the goods as shipped, as invoiced from the shipper. And if we're talking, let's say, about a load of blueberries during a certain time of the year, we're talking about $80,000, $90,000 value container of produce, which for a transportation company can become an issue if their insurance says no to paying that claim. So transportation companies are not obligated to be part of the DRC, but they do have other advantages by being members of the DRC, such as if someone is not paying their freight bills, they can use us, or they use their process to go after the company, either with the shipper or the receiver, to collect the money by using our dispute resolution mechanism. Or our rules by default do not allow to offset claims. Our members are obligated to deal only with the transaction that is in dispute. So companies are not allowed, let's say a transportation company, a carrier has an account with a wholesaler where they do 20 loads a week, and one load is in problem that is a value of $50,000, and normally the freight is $5,000. If they're not members of the DRC, the receiver has the opportunity to offset the $15,000 from the account, and at that point, it affects more than one freight invoice, more than one freight transaction. Our rules don't allow that. So that protects in some way everyone in the supply chain by sticking into the transaction that it's disputed, and everything else needs to be paid as it comes due.
Jamie, hearing all this is causing me to recall dim and distant, foggy memories of my first year of law school and the Uniform Commercial Code and substantial compliance with contracts, and when you have the right to reject a delivery and all that sort of thing. Do those legal standards apply in these kinds of disputes?
Yes, same things apply. So part of the precedence that created these rules comes from the UCC, from the Uniform Commercial Code. And so what that helped us was to establish our trading standards, which, for example, going back to going to what you were saying regarding rejecting a load or what is considered an act of acceptance, our rules define that. Our rules do say that an act of acceptance happens when a receiver receives the load and it unloads it for any other purpose than having it inspected to determine if it meets or fails the quality contracted. If a receiver receives a load and unloads it, and 2 days later he notices that the product has deteriorated, he no longer has a right to reject that load. He has accepted it. He's obligated to pay his invoice price less damages that he can prove. Mind you, there's other rules that intervene in that process, which for our members, they're obligated to notify of an issue within 8 hours of receiving the load. They're obligated to request an inspection within 8 hours of receiving the load. They're obligated to provide a copy of that inspection report within 24 hours of when it's after it's issued. For another part that prevents a company to reject the load is if that load is diverted somewhere else, because something that happens fairly regularly in an industry is I buy the product from you, but I have it and I send a truck to pick it up to your facility, but I have it shipped to my client. That prevents me from rejecting that load to you, according to our rules. It has to come to me first, and I have to inspect it, and then I can reject. So there's nuances in our industry and also in our rules that are very important and need to be followed in order to avoid having a dispute. And you're right. Hearing about this is going back like to school and hearing all this theory, but when it comes to apply it, it becomes a very interesting process.
So again, being a lawyer, I kind of think like a lawyer. What's the role of lawyers in all these disputes at the different levels?
Normally,
Yeah.
very little. Again, so one of the things that DRC looks for in its objectives is to look for as little intervention as possible from legal advice. We always tell our members, if you feel comfortable, like, let's go back to the consultation process and the informal mediation process. During the consultation process, if you have questions about what the rules say about this, we will tell you and we will explain it to you so that you become familiar with that. It's up to you as a member to be more familiar with it and learn these rules so that if it happens again, you know what would apply and what rights and responsibilities you have. But we are normally educating our members through our consultations and also during the informal mediation process, which again, it doesn't cost anything to our members. It's covered by their membership fee. And between 75 and 80% of the disputes are resolved during this process. So at that point, we normally say to the parties, at this point, there's no need to involve a lawyer. Nothing prevents you from hiring a lawyer to help you with the informal mediation process to present your case. But we suggest at this point, try to do it on your own. We will explain you, we will guide you through the process. You have, as a member, the right to learn all of this. And normally parties feel very comfortable doing those things, doing this process on their own and resolving this. Where it gets complicated, it's obviously when it gets to arbitration. And if we see a party that has an issue understanding the law or the rules, we do recommend to them immediately, you're better off getting a lawyer through this process to defend to help you defend your case or present your case. It's during the arbitration process where we tell the parties that you may need legal representation. And again, it depends on the parties on whether they're gonna use a lawyer or not. But at the same time, we do have, aside from our roster of arbitrators, we have a list of lawyers who have approached us in one way or another to be more familiar with us, be on a waiting list to become an arbitrator for the DRC. And if one of our members approaches us and says, hey, I'm having this issue, it may or may not fall under the DRC jurisdiction, do you know anyone that can help us? And then we can provide them a list of lawyers that have contacted us. So we do promote the services of lawyers that want to be familiar with us and want to be participate more with the DRC. Also, another important part is we do obviously need lawyers to help our members enforce arbitration awards or represent them when an arbitration award is being set aside. So again, we recommend 3 to 5 lawyers each time, different ones, depending if they tell us that that's their specialty, that's what they normally do, then yeah, that's how lawyers can get involved with the DRC. And again, one of the reasons why I thought this was a great opportunity for us to be in this session is we're expanding our services. We're thinking that at some point our membership will grow enough that our staff will need to grow too, and obviously our roster of arbitrators and contacts in the legal industry outside of North America, well, within North America and outside of North America. So it's something good to know for lawyers to be familiar when someone approaches a produce industry company approaches them, and letting them know that there is a mechanism like this. I think it helps them promote their services too. And so I've only talked about being members of the DRC, but there's other ways to involve the DRC when parties are not, either the buyer or seller are not members of the DRC. You can use an arbitration agreement, sign an arbitration agreement to use the DRC to resolve the dispute. Or if there is a contract, you can include a DRC arbitration clause, which automatically makes us have jurisdiction over any dispute arising out of that contract. So we normally, if a lawyer is doing a contract for one of our members, we normally suggest that they include that arbitration clause there too.
So at the beginning stages, when someone member needs some counseling or advice as to what the rules are and how to comply with them, that advice is typically given by you or somebody like you who is a member of the staff of the DRC, right?
Correct.
Okay, and then as it goes, no pun intended, up the food chain and more formal arbitration, who are the arbitrators?
So, and you may find this funny, but when the DRC was being created during the NAFTA negotiations, there was a group of lawyers in the United States and Canada that were known as the broccoli bar. And the broccoli bar was known because if you're familiar with US regulations, specifically the Perishable Agricultural Commodities Act in the United States, there were certain group of lawyers that were very familiar and attacked that niche and became focused and only on only resolving or being providing their services for the produce industry, representing companies in disputes where PACA had jurisdiction or the PACA had jurisdiction. And so they helped us when we were creating the DRC because they had all the background, all the knowledge, all the precedents to help us create the rules of the DRC and also be the first ones to become part of our roster of arbitrators. And from then on, when we started growing, we said, okay, we need more arbitrators. Who would you recommend? Do you know anyone in the industry that is doing that too? And also I started, me as DRC representative started participating in other arbitration forums, and obviously lawyers were very amused when I mentioned the name of the company that I was representing and the resolving food fights part, and then so I started, creating relationships with different arbitration lawyer groups in Canada, the US, South America, Mexico. And so, yeah, I've been able to, and the funny part also is that I'm not a lawyer. So I participated in all of these lawyer events, and I was one of the only ones who was not a lawyer but I was very familiar with arbitration proceedings. And so they were kind of amused that I was there.
Fantastic. So, Jamie, tell us about the biggest dispute you've handled, and obviously don't use names of
Oh no, I can't.
parties.
So one of the things the DRC, like I mentioned before, our consultations are private and confidential. Our mediation arbitration procedures are private and confidential. We do publish our arbitration decisions, redacting the names of the parties involved and the arbitrator. So you do have access to that in those. Well, in the arbitration industry, arbitration decisions are not necessarily precedents, but you can use them as guidelines, right, for future cases. The biggest arbitration proceeding that I've participated, it started as an arbitration process between a big retailer and a big grower. And as the arbitration proceeding started, they decided it was better for them to move it to informal mediation, to a formal mediation. And that was I think over a $3 million dispute, because it was a contractual problem that one of the parties was not fulfilling, and it was a seasonal contract. And so it involved produce to be shipped from week 7 till week 80, week 7 to week 45. And obviously that represented millions of dollars. Part of the contract was fulfilled, but another part of the contract was not fulfilled. And so that was a very interesting case. Another one that became really interesting for us was a dispute, again, over a contract that was not fulfilled during COVID, during the pandemic. And at that point, there was a contract, but if you look at those contracts, the word pandemic was not included in those clauses that talk about acts of God or anything similar. And parties were making, obviously the receiver was making the argument of why the supply chain was disrupted and he could not sell and move the amount of product that is being was supposed to be shipped by the shipper or farm. And the farmer was saying, yeah, but there was nothing preventing you from doing it and looking other channels to move your product. At the end, the arbitrator had to make a very tough decision as to whether considering the pandemic was an act of God or not. He decided not to, that it wasn't. So that was a very interesting case. But also you have to look at the facts, right? And there were several aspects of that dispute, certain elements that made it really interesting as to why the arbitrator decided that the pandemic could, for this particular case, could not be considered an act of God.
Fascinating stuff. We have just a couple minutes left. If there are any questions from anyone in the audience, Eugene or Natalie or anybody else, please just unmute yourself and ask.
Jamie, this is Jean. Hi. I'm surprised that insurance isn't involved in more of these claims. Why would that be?
So again, not all of our members use insurance. Insuring a crop sometimes can be very expensive. And again, you're not normally dealing with the actual grower who's having the dispute, which normally their crops are insured. But that's related to, again, acts of God or any of those situations. But in reality, when there is a dispute over a quality of the product, the insurance company is going to say, I don't want to get involved in this because I'm not sure I would be able to collect anything from the other party when there's a valid dispute presented by the receiver or something. So insurances, here's another. I mean, this I can tell you about this case because it goes to this. A company in Canada and a company in the US enter into a contract. Both were members of the DRC. They had a dispute. And the company who shipped the product said, you know what? I'm going to collect the insurance. I'm not going to go through the DRC process. And so they went through the insurance the insurance paid them, and then the insurance went after the other party legally. Guess how the other party defended? I have an arbitration agreement that says that disputes between members of the DRC have to be exclusively resolved through the DRC, so I don't have to pay you anything, because legally they should have come after me to resolve this dispute through the DRC. And they took it to court. The court told them it has to go back to the DRC. So the insurance company then decided, okay, I'm gonna try to collect my money back from from the company I insured. And at that point, the company insurer said, no, I don't have to. You already paid it. You have no legal grounds to get back after me. So insurance companies, we try to maintain them outside of this process. I mentioned the transportation part, a little bit about insurance for the carriers that they must have, but we don't really, it's not that we don't care, but we don't really take into consideration whether insurance covers it or not, because for our members are obligated to use us. Obviously, our member who went to the insurance, instead of filing a claim against the other member, in the case that I just mentioned to you, he faced repercussions for not following DRC rules. But at the end of the day, another thing entered to play into this dispute, which was the statute of limitations. It's interesting how everything got involved in that particular situation.
Essentially, no subrogation back against a member of the DRC.
No, you can subrogate your arbitration rights, and again, nothing in our rules allows for that. Nothing prevents the parties to do that from doing that, but you have to have an agreement, a subsequent agreement, right, allowing for that to happen. In this case, the insurance company tried to file a claim through the DRC as a representative for the member of the DRC, and we said, you can't. You're not a representative. You actually own these invoices now. You're the owner of those invoices. You contractually, you can't.
We're out of time. This has been the best food fight with which I've been involved since I saw Animal House. This was just great. Jaime Bustamante, thank you so much for this incredible insight into dispute resolution in the produce industry. We encourage everybody to contribute, if you're in a position to do so, to the Ottawa Food Bank in Jaime Bustamante's honor. It's been a great hour. Thank you all very much. And with that, we are complete.